Okay, we're going to go ahead and call to order Monday, April 30th, 2018, the Budget and Finance Committee meeting. For the sake of time, for those that may have questions, just come on up and state your name and your department for the viewing audience. And having said that, we're going to begin with resolutions. RS 2018-1158 sponsors Glover and Hastings, approves the issuance of public facility revenue improvement bonds by the Sports Authority of Metro, authorizes certain revenues of the Metro government as security for the bonds, and authorizes an official statement to be distributed in connection with the sale of the bonds. There is a letter for approval. Is there a motion? It's been moved and properly seconded. Any discussion? Councilman Glover. Councilman Roden.
Who seconded the motion?
Councilman Prodmore. Any discussion? Councilman Glover.
Thank you, Chair. So I think we all got the letter that came in from our finance director. First of all, I want to address various issues that are placed in here. Here's the one thing that confuses me the most. In the resolution that we passed before, and it's not addressed in any of the analysis, it's not addressed in the letter, but it was clearly addressed in the resolution that I have placed along with Councilman Hastings before the body. And that is negotiable bonds versus competitive bonds. Because if I go back and I look on November 21st of 2016, we clearly stated, and it was clearly stated in the Tennessean, that we would move to competitive bond issues because it literally would mean millions of dollars savings for the taxpayers of Nashville. So can somebody help me address why that's not talked about in the letter or analysis or anywhere that we, on any of the information we got?
Councilman Glover, we'll defer that to the administration table.
Okay, thank you.
I guess I just want to make sure that I'm going to follow the line of questioning, but these are revenue bonds, and it is still our intent to use, to the extent possible, competitive bids on for general obligation bonds.
Okay, and so competitive bidding is not available on revenue bonds?
No, they are. That's what I'm saying. Our intent would still be to do that. I'm just saying that that's a different kind of structure.
Okay, well, while it may be a different...
It's not required by the state. It's not required, but we...
Okay, but we clearly put it in the language on the resolution we passed that it would be a negotiable sale versus a competitive sale.
The resolution would not preclude use of a competitive sale because the Sports Authority is who would issue the bonds, and so they would be making that decision.
Okay, well, I guess I get concerned when I kind of go back and I try to look and understand what it is we're trying to accomplish, and if competitive bond issues will save the taxpayers money, then I think we should always certainly do that. So I just didn't understand why that flowed the way it did.
Yeah, and that is absolutely our intent, and we work with our financial advisor on identify those and helping us with the bidding process to identify the issuers.
Okay. All right, so let's go into the letter that you did. The resolution in question purports to remove references to the fairgrounds as to not limit construction of the MLS stadium to the fairgrounds property and allows it to be constructed elsewhere in Davidson County. I think what it says is that it could be built at the fairgrounds, but that we look at other opportunities in Davidson County. I don't think that in the resolution it states that we will not build it at the fairgrounds. And if I said that in the resolution, then certainly my apologies, because that's not the intention.
Okay, thank you.
Let's go to point number 2. The $50 million for the fairgrounds that we put in there, for $25 million being for the stadium, and then $25 million being for improvements to the fairgrounds. I mean, a little over 8 years ago, 71% of the people in Nashville voted to preserve the fairgrounds. Now, you know my opinion on this. I think we're ignoring them in some of the things that we've done here. But we really haven't done much to help that. So I really tried to mirror as closely as possible what the original resolution was and leave the options there. But I also felt like the fairgrounds needed to have attention and a little tender loving care. So that's why I left that piece in there. Now, if I jump on down, it says, thus Metro, and I'm reading the letter that you sent to the council. Thus, Metro would still be obligated for stadium-related expenses at the fairgrounds and stadium-related ground lease prior to issuing. Well, Mr. Jameson, here's my question. Can this be amended to where if we in fact determine another place might be more suitable for the fairgrounds, other than the fairgrounds for the stadium, I mean, we could amend this part of the language, could we not?
The only site that is contemplated in the resolution 910 in 2017 was the fairgrounds site. The site is defined as the address on Rain Street for the fairgrounds. There's an intergovernmental agreement that refers to the site as the fairgrounds.
Okay.
So if the preference is to select another location, the current resolution is problematic for a couple of reasons. You've explained, I think, well, your intention with respect to the 50 million GEO bonds. You intended for the 25 million to go to a fairground site because it had been neglected, as you saw. You still got 25 million dedicated under 910 for the infrastructure around a new stadium. That's still in your resolution. Mm-hmm. And that's why passage of this in conjunction with 910, I have to assume, is one of the reasons why Talia could not sign the letter certifying the funds.
So that part, if we, so give me your analysis on, do we need to amend it and even perhaps defer tonight in order to have it amended to where we change that language somewhat?
You would have to go back and at a minimum amend 910 to reference another site and amend the intergovernmental agreement. And I would, if I were you, at least defer the current resolution.
Okay. Well, if we do something of that nature, here's the one thing I've heard is that if we don't do it at the fairgrounds, the city has legal liability. Have we signed a contract? Has the city signed a contract on this?
No, I would acknowledge that anything that came across as a threat from the letter from Mr. Ingram or whoever may have been overstated. I mean, there clearly were conditions remaining before a stadium is proceeded with, including the much noted 27 vote minimum required, charter required ordinance that approves any demolition on the grounds. So any reliance by those who spent apparently significant sums of money on the resolution in terms of the liability it creates for Metro, I think is a little overstated. They may have still nevertheless relied and acted, but I think that's more to their detriment than to the council's.
Okay, so let me just make sure that I clarify what I think I just heard. The city, in your opinion, does not have a liability on this because we have, as of yet, entered into an agreement on a lease or a stadium or anything else. All we've done is voted to allow the Sports Authority to issue bonds to build the stadium after we meet all the other conditions.
And
did I understand that correctly?
That is correct. And 910 specifies a multitude of conditions, all of which have to be met, all of which have to be met. And there's one that has the high threshold for 2/3 approval by this body, and that could fail. And that does not in and of itself create liability for this body, in my opinion.
And so if that does fail, then what does that do? Does that, do we then, do we still build the stadium there? I mean, what happens?
We would not, presumably would not build a stadium.
We wouldn't build a stadium. Okay. Okay. All right. So let's go back into somewhat, a little bit more of the letter here. It says, in the third paragraph, about third sentence. While there are several conditions that need to be met prior to the issuance of the stadium financing, the designation of the stadium location is not one of the conditions contained. And that's really where I was asking the question just then, because frankly, I think it's a little frustrating and perhaps irritating for those of us on the council when it sounds like that the city has legal liability, that we can be sued when we have in fact not entered into an agreement to do this yet. And if it clearly stated in the stipulations that you have to do this, this, and this before we would move forward, that's where, for myself, my frustration comes in, and I guess my confusion falls. So I'll go to the last question, and Chair, thank you for indulging me. Since the team has already spent a considerable amount of money on reliance on the council's designation of the fairgrounds as the MLS stadium site, the metropolitan government could be exposed to significant financial liability. So I think, Mr. Jameson, I don't want to, again, I'm not a lawyer, but I think we just had that conversation, and as of right now, the city does not have that liability. In your opinion?
In my opinion.
I'm sorry?
Yes, in my opinion, again, 910 specifies a multitude of conditions, any one of which could result in the failure of that condition and the failure of the entire project, and that would not create liability on the part of the council. If the ordinance, for example, fails and gets 26 votes, that in and of itself would not result in liability.
Okay. All right. So I think what I'm going to do, because there's that one piece with regards to the 25 and the $50 million piece. Chair, I'm going to move to defer one meeting. Simply because I want to make sure that we clean the language up. Mr. Jameson, is that the proper move to do that, to where we can change the language in this?
That's fine.
Okay, so I will move to defer one meeting.
There's a motion to defer. Is there a second? Councilman Pulley, discussion on the deferral?
Sure, we can make this discussion on the deferral. Just to be clear on the financials, being as we're talking about them, the $50 million, it's my understanding that 25 of this is paid by the team. Is that correct? So 25 for infrastructure improvements that we are paying for, and the 25 for fairgrounds improvements go to them. Is that the way
There was a required capital contribution from the team.
That's right. And of the remaining $225 million in revenue bonds, the team, under a structured lease, is essentially responsible for paying the debt on that. Is that not correct?
That is correct.
And I think we went over a lot of effort to vet the financial solvency of this league and this team to mitigate any liability that we may have moving forward in that when we passed 910. So is it a part of this resolution that there's some impact with the fairgrounds being the site which was chosen for this stadium? Is that the way I understand this resolution?
That's correct. I think that was unintended, but again, in 910, you had $50 million in GO bonds that were being contemplated, split down the middle. 25 of that was to go to improvements of existing fairgrounds facilities, to everyone's gratification. But the remaining $25 million was to go to infrastructure that surrounded the new stadium, new sidewalks, et cetera. And so if the intent is to remove the fairgrounds site by virtue of this new resolution, it doesn't make sense to appropriate $25 million to improve a phantom stadium infrastructure.
I hear you. And, quite honestly, I don't even know why we're going to be talking about it if we're going to move the fairground site, because it's been made clear by the MLS. It's been made clear by the ownership group. I certainly take them at their words that if this thing's not going to be at the fairgrounds, then we're not going to get it. So for that reason, I certainly don't support the new resolution, and I would not support a deferral. I'd like for this to come to vote tonight, and let's go ahead and deal with it here and now. Thank you.
Councilman Mendez.
Thanks. I guess whether it gets deferred or if it gets deferred, there's a nuance on the legal liability that I'm interested in hearing about. And so Mr. Jameson, I hear you saying that if one of the conditions that we stuck in 910 doesn't come true, that there couldn't be liability there, and that's your opinion, and I agree with that. I guess the nuance that I'm interested in is, so we're not talking about one of the conditions that we put into 910. We're talking about sticking on what would likely be construed as an additional condition. And the question that I haven't quite heard the answer to, I think maybe I missed it, is that is there the potential for liability for the city if we stick a new condition on after the fact?
Absolutely. And the additional risk, of course, is that if the fairgrounds site is not approved, we do have a written statement from the team owner, primary owner, that risks the MLS expansion, that the deal falls apart if the fairgrounds are not cited. But yes, if we add new conditions to what we previously set as the base conditions, that could be grounds for liability.
All right, thank you.
Councilman Cooper.
Thank you, Chairman. Just a couple of quick questions for further information on this. I guess 3 questions for the administration table. Is there a thought about when the 27 vote condition would be scheduled for? There's not currently a timetable, okay?
No.
Thank you. Because, again, everything we're doing is kind of in the shadow of that, so I thought I would ask. Secondly, were there ever any site selection materials for the selection of the fairgrounds? Was there, going through my file a few months later, I didn't find anything. Is there I know I see the Director of Public Property here, is there a folder? Was there a process? Was there a survey? Were there other sites examined that there is a work product that we can examine?
We're not sure. We're going to have to follow up on that one.
If you would, that would be great. And the third question, it came up before. These bonds are not in the CIB. And is there an effort to put them in the CIB? Again, we're issuing revenue bonds that have never been authorized in the CIB.
There is one. There is a project in the existing one, but this would need to be considered in the upcoming CIB that is presented before this body. That'll be filed on May 15th.
So you will be putting that in the May 15th CIB, because ultimately we've been having CIB requests from the council has been coming in, and our timetable for putting things in the CIB has expired, hasn't it?
Correct. The CIB has been approved by the Planning Commission and is now with the mayor.
Okay.
For the mayor to put in his recommendations for filing by the 15th.
But both the revenue bonds and the GO bonds are in the mayor's submission that's before the Planning Commission now.
I'm not sure if they've already been submitted, but they will be included.
Okay, all right. Just thought I'd bring this up in case it hadn't been. I think that would be important. Thank you, Madam Chairman.
Thank you, Councilman. Councilman Glover.
Okay, thank you, Chair. Mr. Jameson, in my resolution, does it say we will not build the stadium at the fairgrounds?
No.
Okay, it does leave that option open, correct?
To the extent it doesn't specify the location, then yes.
Okay, well, I mean, and so therefore, again, I've tried to explain this to a number of people. If we build at the fairgrounds, okay, but I think we have a process we should have followed, which we did not. You know, we're talking about a 30-year lease on a stadium. We're talking about a 99-year lease on a piece of property. I think we've talked about the fact that no land was surplus, nothing was done in that arena. And I think what Councilman Cooper, the question he just brought up is extremely significant. Was there any other homework done on other locations? Because I'm like you, I don't think I remember seeing anything. So if in fact we didn't, I guess the real question is why? Why didn't we? And so, I know the people in my district are not for giving away land. You know, they're not necessarily against the soccer team, nor am I. But I want to go back also, and just for clarification on the 25 million, we would be obligated under the resolution that we passed. It was my understanding we'd be obligated for a total of 275 million. The city would be signing off on whether it was a revenue bond or GO bonds for a total of 275 million. Did I misunderstand that?
Attorney Cooper?
If you include the $25 million for improvements to the fairgrounds property to rebuild all of the buildings, which is related to but not a part of the construction of the stadium, then that would be correct. It would be up to that amount.
Up to 275 million. I just want to make sure that I'm very clear on understanding what the numbers are. So with that, we'll do whatever the committee so chooses tonight. But I certainly feel like that we probably need to go in and amend some of the language, and then if it passes, it passes. If it doesn't, it doesn't. But, I think what might be fun is if we actually have all the information before we vote on something, and we understand exactly what we're doing. So with that, I will renew my motion to defer one meeting.
Thank you, Councilman. There's a deferral on the floor. Councilman Davis, you're recognized.
Thank you, Madam President. Mr. Jameson, just so that I'm clear, not trying to be redundant, okay? So eventually there's going to have to be a vote that needs 27 in order to tear down the buildings or a building at the fairgrounds. Is that correct?
That's correct. Under the charter, section 11602, it was amended a few years ago. I think one of the gentlemen responsible for the amendment is in the room with us today, and that requires before any demolition of the fairgrounds premises that this body pass an ordinance that passes by 27 votes.
And allegedly, I believe there is a contract or something signed between the Ingram Group or Mr. Ingram and the MLS. We received a letter stating that basically if it's not built at the fairgrounds, it'll be subject to some liability on our end or something like that. That was written from the Ingram Group.
What I think Mr. Ingram is referencing, the second part of that letter indicates that if the fairground site, that we do not proceed there, that risks the MLS approval, that he would lose the franchise at that point.
Okay, I did not go to a fancy business school, but I went to business school, and I know we have a lot of lawyers in here, and there's still parts of this contract that needs to be executed because we celebrated the coming of this franchise, but the job wasn't done yet. It was kind of like we were celebrating, hey, we got this, hey, we're happy, but part of the obligation was the 27 votes and, to build the stadium. Is that correct?
Correct.
And they knew this. Or I don't want to speak for Mr. Ingram, but it would seem to me, being a smart businessman like himself and having the team of lawyers he has, being a successful businessman like himself, wouldn't he realize his chickens weren't hatched yet? Or that this part of the contract hasn't been executed?
Again, there are about 10 preconditions that are included within the resolution the council adopted in 2017. And the failure of any one of them could result in the total failure of the resolution of the stadium at the fairground site. And by virtue of the failure of any one of them, this body is not responsible. If the body does not pass the demolition ordinance by 27 votes, that does not result in liability to this body.
Okay. So when going back, I just want to make sure the people back at home are asking questions about this. So let's take, for example, when Top Golf was built in my neighborhood, we had to vote on that. We needed 27 votes on that one. And they didn't break ground or celebrate or announce anything like we're coming, we're here, until that was done. Now, prematurely, we could have been like, had a river come, had a big celebration, or something like that. But we didn't do anything until that vote was done and counted for. And I'm just making sure that this is correct, because, you know, I get a lot of questions from both sides. I want to build it there, or I want to build it in North Nashville. And I just want to get a clear understanding, you know, because people saying, well, Metro is liable. And if we have not taken that vote yet, I don't see our liability. But once again, I'm not an attorney. And my biggest concern is not if it gets built at the fairgrounds or it gets built in North Nashville, because I want it. But my biggest concern is that I'm all for giving Mr. Ingram a 99-year lease. But I want to do that to other properties and for other businesses, you know, in north, south, west, or east. You know, these similar deals. And the fear is, from my community, is all of a sudden Metro is going to get amnesia once, you know, this happens, and when there's a better deal coming somewhere else. You know, we'll forget that we did this 99-year lease. And that's the biggest concerns I'm hearing. And maybe something else, but, you know, I'm all for, you know, giving this gentleman, you know, 10, 12 acres somewhere to build the stadium and the affordable housing and with the community benefits agreement. But I just want to make sure it's clear, you know, to this body and to the administration that when it's time to do something like this in other parts of Nashville, that we honor, we look back at this and we don't get amnesia. And that's all I have to say. I thank you for your time, Madam Chair.
Thank you, Councilman. Councilman Sledge.
Thank you, Madam Chair. I appreciate it. I'm not on the committee, but obviously this impacts
You're recognized.
the district I represent. So just real briefly, I want to just give a couple of points to the committee. So I do believe in one of the letters from the team that they did indicate that there had been some diligence that they've done on other sites that they've done with MLS to say, where do you want to go? And MLS and the team and Metro, meaning the administration, I suppose, all agreed that this site was the best site. I think our vote reflected that as well. I have a little bit of trouble squaring when folks say that they want a team, and then when they get a letter from the team ownership that says, if we move the site, you'll jeopardize the team, and then the same folks say, well, I want to move the site. I just don't think that logically squares up. And so what I'd ask the committee to consider is, the more that we have these conversations, I think the more uncertainty it creates, really for no reason at all, I believe, because I think there is the possibility to achieve every stipulation or every part of that that Attorney Jameson has referred to, and I think we can do it in a collaborative manner. So I would ask the committee to consider not deferring this and just taking an up and down vote on it. Thank you.
Thank you, Councilman Sledge. Councilman Mendez.
Thanks. So when we passed this resolution 910, I just looked at it a couple seconds ago. There's 10 conditions we built in, covering nearly 2.5 pages, single space, small print. Some of the conditions have multiple subparts, and that was a negotiation. We passed it, and I think that to one of my colleagues' points, the team did have a whole bunch of expensive lawyers, I think, and what they are relying upon is that after a whole lot of conversation and more than one meeting, the council came upon a list of 10 single space, 2.5 pages worth of conditions, and the issue that I think we're facing today is whether we're retrading that deal, whether we're going to change the conditions or whether we're going to give the team a fair chance to follow through on the conditions that we as a body negotiated and came upon, and I think everybody remembers there were pretty dramatic changes to and additions to the list of conditions. And so my sense is I feel like we're retrading the deal a little bit. I feel like we came up with a long list of conditions. The deal was if the team and the administration meet the conditions, which They might not, especially on the 27 vote for the demolition, they might not. But we set up the conditions, and we should live with them just like we're expecting the team to live with them and give them a fair chance to see whether they can meet them all. So as this, I was interested in hearing the conversation today, but as it's gone on, I think my view is that it feels like we're changing the deal, and I guess that makes me opposed to the resolution. Thank you.
Thank you, Councilman Mendez. Councilman Glover, you're the last one, then we're going to take the vote on the deferral.
And that's fine. One of the reasons I asked the question is, did we remove the fairgrounds out of my resolution, was because I think that's a key point. If in fact that's the location of where it has to be, needs to be, et cetera, I think once we receive documentation and some of the questions that have been asked here today, then, you know, I did not pull it out of the resolution. So I don't necessarily think we're, quote, changing the deal. On the negotiated versus the competitive bidding piece, yeah, I'm changing that deal because I think if we understand it completely, we'll understand that could save us millions of dollars. The other thing that we haven't really talked about, and I kept asking the questions, and I had it forwarded from Mr. Jameson today, was it was a 90-10 deal. One thing that's not talked about in the 90-10 deal is the $4 million we're on the hook for the first 5 years, and then $3 million for years 6 through 10. So, you know, I just feel like that one of the reasons I left the fairgrounds in there was to say, fine, if that's where it has to be, but we certainly did not follow our own rules on the way we did this deal. And I have to agree with Councilman Davis. Until you have the 27 votes, then apparently what I'm hearing is you don't have a deal. So I guess if we don't have the 27 votes, then I guess we're still in jeopardy. Is that what I'm hearing, Mr. Jameson?
If you don't have the 27 votes, in my opinion, that does not create legal liability. However, if you impose new conditions, that's the problem. You had, again, roughly 10 conditions established in November of last year. If any one of those fails, that is not necessarily the fault of the council. On those conditions, they will be coming to you for approval. Lease terms will be coming to you for approval, for example. If those fail, that does not create liability. If, however, you add to those conditions brand new hoops and hurdles that the team has to go through, that is not what was negotiated in November, and that could be grounds for liability.
Okay, well, I will end with this. I still think the key thing that's in here is moving from negotiable to competitive on the bonds. It does not remove the fairgrounds as far as being a site, but it does look at, you know, did we do our due diligence on behalf of our taxpayers? Thank you, Chair.
Thank you, Councilman Glover. Mr. Jameson, just to be clear as it relates to the contract is between MLS and Mr. Ingram and not the city, correct?
Correct.
Okay. Seeing no further discussion on the deferral, all in favor?
Aye.
Opposed?
Show of hands.
Need a show of hands.
All in favor?
All in favor? On the deferral.
All opposed?
All opposed?
So deferral fails 7-3.
Deferral fails 7-3. Now we're back on the motion. You got a comment, Councilman Glover? Councilman Glover?
Thank you. All I'm going to say is, I mean, we've got a couple other committees to walk it through. I don't think my work's done here. I still do not think that we vetted as well as we should have. So I will go back and I will look at how we, you know, how perhaps I proceed along with Councilman Hastings. He's out of town, and so I won't be able to talk with him. But I mean, we'll just go ahead and I can only assume I know which way the vote's going to go right now. That's fine. But I think that the deferral would have been the right move. But we've spoken. Thank you.
Thank you, Councilman. Councilman Davis, discussion on the motion? You're okay. All in favor? Show of hands.
And opposed?
Opposed?
However you're voting. Opposed. So fails. Fails 7-2.
Resolution fails 7-2. RS 2018-1161, sponsors Sledge, Mendez, and Vercher, authorizes the Metro Development and Housing Agency to enter into a pilot agreement and accept payments in lieu of ad valorem taxes with respect to a multifamily housing project located at 60 Lester Avenue. Is there a motion? It's been moved and properly seconded. All in favor? Opposed? Resolution passes. RS 2018-1162, sponsors Sledge, Mendez, and Vercher, authorizes the Development Housing Agency to enter into a pilot agreement and accept payments in lieu of ad valorem taxes with respect to multifamily housing project located at 310 Stanley Avenue. I believe there's a substitute. Councilman Sledge.
Oh, thank you, Chair. The substitute, it just corrects a typographical error. It changes avenue to street in a reference. Just want the committee to know.
Can I get a motion to move the substitute? It's been moved and seconded. Any discussion? Seeing none. All in favor? Opposed? Substitute passes. Now we're on the bill. The resolution is substituted. All in favor? Opposed? Resolution passes. RS 2018-1163, sponsors Wazo, Mendez, and Vercher, authorizes the Metro Development and Housing Agency to enter into a pilot agreement and accept payments in lieu of ad valorem taxes with respect to a multifamily housing project located at 1136 Massman Drive. Is there a motion? It's been moved and properly seconded. Seeing no discussion, all in favor? Opposed? Resolution passes. RS 2018-1164, sponsor Vercher, appropriates $2,060,600 to certain accounts for the benefit of the Election Commission. Is there a motion? It's been moved and properly seconded. Councilman Glover.
Okay, so in reading this, can somebody help me explain why we're going to have to spend $2 million when perhaps we should not have been spending $2 million for a special election? And I know we got differing opinions. I get that piece of it. But when we look at our charter, when we look at how it's written, again, I'm not an attorney, but let's explain how we are where we are and why we have to spend $2 million.
Definitely, and just so that the committee knows that invitations have been extended to the commissioners, and to the Election Commission, and to all parties that were involved to get us to this juncture. We owe it to the city to account for this additional supplement. You can come on up.
My name is Jim Delanis, and I'm the chairman of the Election Commission. We have our other commissioners here, Ms. Hertzfeld, Mr. Starling, and Ms. Reynolds, and Jeff Roberts is here, who is the head administrator of our Election Commission, and I think we do have our legal counsel here from Metro Legal. Does the chair want us to address the question then?
Absolutely.
Okay. All right. Essentially, the decision was made by the Tennessee Supreme Court that reversed the decision of the Election Commission and directed us to not have the mayor's special election on August 2nd, but instead it had to be handled as a special election and moved back to May. We had made a decision to set that election in August when it would have been combined with a general election. and the Supreme Court decided upon reading the charter that they did not agree with us, and therefore directed us to have a special election, which, based on the timing of the Supreme Court's decision, had to be held on May 24th, or within a very narrow window of time right around that time period. So the longstanding policy of this commission and in a couple of court cases that had approved that policy in the past, we set the date on August 2nd. The case went up on appeal, and the Supreme Court reversed our decision and the lower courts that had ruled with us previously. So that is why we've got the election on May 24th, and that is why there could be additional cost. And I would note that during the oral arguments on this, when we made the point that this could cost the city money, the Supreme Court recognized that. They expressed their concerns about that, but nonetheless, they decided upon their reading of the charter that we had to have a special election. So that's where we are for this election for the mayor, and this could happen again, depending on how the time periods fall. We could end up with more special elections than we had under our previous policy.
Thank you, Mr. Chairman. You can just stay right there. Council Lady Allen.
I think this relates more to things that are coming up in the future. Every time we have a special election for a citywide, will it run about $2 million, or is this one more expensive because it was done in a short time?
No, I think the two, and Mr. Roberts can address this better than I think the two is for two elections. We may not have the second election.
But that's the runoff, correct?
That's for a runoff.
Gotcha.
And that could happen anytime we have a special election.
Thank you. Let me ask it a simpler way then. So every time we have an election citywide, is it about $1 million? I mean, can we sort of figure on that more or less?
That would be a number that I would kind of keep in my mind.
Gotcha.
This election, May 24th, is going to be a little more expensive because we have a very abbreviated time to make that happen. So the staff at the Election Commission are working many hours and costing more overtime than we normally would.
Gotcha. And we appreciate that.
But that applies to an election for the whole county. If, for instance, this were a district council race,
right,
it would be substantially less expensive.
Maybe 1/35 or not?
I'm not sure one, but certainly substantially less.
Okay, I think that's relevant. I mean, I think we need to keep that $1 million price tag in mind as we talk about other resolutions coming before us.
Thank you, Council Lady. Councilman Glover.
So I want to get clarification on something that was stated at the end, that we could have other special election coming. I don't think, based on the timetable of what I've looked at this point, if in fact we go to a runoff and it's June, was it 28th or something like that, 26th, 28th, whatever it is, I don't think there would create another special election this year, because I think we've missed the window with regards to the vice mayor's race. So can I get clarification on that, please?
I think that would be directed to the legal department.
Attorney Cooper?
My understanding is that if there is no runoff at the May 24th election, if someone wins outright 50% plus one, then my understanding through guidance from the state is that we would have an election, but I think that would be in conjunction with the August election. So that would be August 2018. If there is a runoff, which would be June 28th, and again, I'm talking, well, it all hinges on who wins. If Mayor Briley wins, then you would need to fill the seat of vice mayor. And so you're looking at that election would probably be in August, but if it's a runoff and Mayor Briley won in the runoff, then the timing is different. You couldn't make the August election. So I think that may be the issue.
But are we not within a one-year window at that point to where the charter doesn't address? I mean, if we're within a one-year window of the next citywide election for the council and mayor and vice mayor, I don't think our charter requires us to hold a special election, does it?
There's nothing in statute that would set a qualifying deadline.
Councilman, legal is consulting.
So for the vice mayor, the provision for mayor in the charter in 1503 is different from the vice mayor. So you would not have a special election for vice mayor. It would just remain vacant until the next term. So the only way you would have any other special elections would be if you had additional vacancies. I mean, it just depends on who runs and who gets elected. But you're right. For the rest of the year, we would have less than a year after the August 2018 election.
Okay,
So we don't have any more special elections this term.
So then it will fall upon the council to elect another pro tem, is the way I read the charter.
That's correct.
If we have a runoff.
Correct.
Okay. Thank you, Chair.
Thank you, Councilman. Councilman Pulley.
I just have a quick question, and forgive me if you've already answered this. I missed the first part of your speech. I was slightly distracted. But if you had taken the position that the Supreme Court took in their latest ruling, would there be no special election? Would you be able to put this in conjunction with the May 1 election? Is that what you're saying? Or are we going to be spending this money anyway, regardless?
If the Supreme Court had made a decision.
No, that's not what I'm asking you. Okay. If you had taken that position that they took initially.
If we had taken the same position initially that the Supreme Court had made, we could have combined this race with another race. We have the discretion if the special election falls within 30 days of another election, we have the discretion to combine those. So yes, if we had been able to predict, and if we had predicted the Supreme Court's decision, we could have combined we could have combined two elections and saved the money. Instead, we followed the existing policy, set it in May, and combined it with another election at that time.
So to Councilman Glover's point, I guess that's why we're spending the money, is that we had a different position and they overturned that.
Yes.
Okay, thank you.
Yes, and I was speaking hypothetically when I talked about this could happen again. There's nothing, there's nothing happening right now that tells me that there is another special election that's going to be needed. But if somebody resigns in the future, depending on when that resignation occurs, if it occurs so that all the deadlines we have to meet sets the election so that it's not within 30 days of another election, then we will have to have a standalone special election, which will cost somewhere close to $1 million if it's a county-wide election.
But you now will have a policy that will reflect what the Supreme Court ruled, is that correct?
We have to, yes,
okay,
absolutely.
Mr. Chairman, why did you have the position that you had?
Well, it was number one, it was a position that had been affirmed by other courts in the past. It was the advice of our legal counsel, and it would combine two elections based on our legal counsel's reading, which I happen to agree with. Not everybody on the commission agreed with it, but
you agreed in which way?
Well,
in the interpretation of the Supreme Court or with our legal?
I personally agreed with the existing policy, practice, and court decisions that would have set the mayor's race in August, and that position was reversed by the Tennessee Supreme Court.
If you don't mind sharing, just for the viewing audience, if you can recall, what was that vote that made the determination?
That was a 3-2 vote. When we took the vote in March, when we had voted earlier on a district council case, which is essentially the same legal case, the same legal issue, the vote was unanimous. And I would also point to the fact that in August of 2014 and August of 2016, we had followed that policy, and then we did the same thing as to a district council race in 2018. And there was a unanimous votes, I believe, in all of those three instances.
So, Mr. Chairman, as it states as it relates to the Davidson County Election Commission, your statements as indicated on the website, the commissioners are charged with ensuring compliance of state election laws. So with your statement that you just indicated, does that mean we have been out of compliance with state election laws?
I don't believe so. We were affirmed on 2 occasions. If we disobeyed the Supreme Court's ruling, then we would be out of compliance.
So before the ruling, the interpretation was just up to basically our interpretation of the law?
Well, it was legal counsel's interpretation, which had been affirmed by the circuit court in Davidson County on 1 occasion, and other authorities in addition to that. So the Supreme Court's recent decision does not, so far as I know, invalidate anything that happened in the past. It just told us how we needed to operate in the future.
Before we charted on this path, did we have an opportunity so that we wouldn't be at this juncture? I do recall, and I'm looking at the letter here, and the council, we weren't privy of conversations as it relates to this matter, but once we became aware of it, we issued our own statement, not taking a position as it relates to the interpretation of the law. We issued that letter March 20th. If a decision had been made as it relates to what the Supreme Court decided, would we not be in this position now? Would we have been able to absorb the election May 1st?
Well, if you're referring to a letter written by 17 council members that was sent to our lawyer.
That's what I'm referring to.
Okay, I've seen that. I thought that letter, I did see it after the fact, and I thought that letter signed by some council members just said that our legal counsel should request that the Supreme Court take the case. If the Supreme Court had not taken the case, we would still be having our election on August 2nd. They did take the case, and they ruled that we would have to spend the extra money on a special election.
Thank you, Mr. Chairman. I don't know if he's here, but his presence was requested. Again, this is for the viewing audiences as it relates to this account, so we can provide the city with answers. Is Attorney Holland here? I don't know if, can you come up? Thank you. We're trying to understand with clarity how we got to this juncture from your perspective.
Thank you, Madam Chair. Jamie Holland. How we got here, you know, the mechanism was a lawsuit, but it started March 9. That was in the initial meeting of the Election Commission. I attended the meeting, asked them to do it. You know, I used some language, said a bunch of fourth graders could figure it out. And the good news is we've got at least 5 members of the Tennessee Supreme Court that can read equally as well as a group of fourth graders. But it could have been May 1. Then on March 26, the Election Commission had another meeting. And I was the only member of the public there, and I asked them again to please take this one last opportunity to not set fire to $2 million of taxpayer money. As soon as I got done talking, they adjourned the meeting. Because after March 26th, the ship kind of sailed. In other words, that election can no longer be held May 1. I think it's a tragedy for the taxpayers. We shouldn't be here. It was entirely unavoidable. This is a crisis of their own making. And if I was the chair of the commission, based on the comments in the March 9 meeting, and now we're coming here asking for $2 million, I'd resign. I wouldn't stay there. And I know this body doesn't appoint those members, but I would start circulating a letter and send it to the appointing authorities that do and ask for him to be replaced.
Thank you, Mr. Holland. Council Lady Henderson.
Thank you, Chair Vercher. I have a question for Mr. Holland, please.
Mr. Holland.
As long as we can talk about short-term rentals too. I'm just teasing.
Mr. Holland, who was your client in this court action?
Ludi Wallace.
Is Mr. Wallace running for mayor?
He's a qualified candidate for mayor. Yes, ma'am.
Okay, thanks.
I hope you vote for him.
Thank you, Council Lady Henderson. Council Lady Allen.
Thank you, Madam Chair. I appreciate the opportunity to speak again. This is a question for one of the legal folks up there. When I read the Metro Charter in Section 15, it talks about general elections, and underneath it, it has two paragraphs. One is about the council members and the mayor and the vice mayor, and one is about the judicial elections underneath the heading of general elections. Can somebody legal say, does it seem logical to think that since those elections, and it says they happen in August, and I'm not a lawyer, so I just was using common sense, and that made sense to me. And I can see how that would make sense to two courts and to the Election Commission. How does legal stuff work? I mean, is there a reason that that wouldn't be assumed, that because it was under that heading, it would be one of those?
Attorney Cooper.
Well, for purposes of the district council members and mayor, in Section 1503 of the Charter, the Supreme Court interpreted the phrase general metropolitan election or metropolitan general election, whatever the word order is, that means the election where the council and mayor are elected, which is the first Thursday, of every 4 years. Previous courts, a previous district judge had interpreted that to mean that is any general non-primary election where metro offices are on the ballot, which would include the judges and the clerks and all of the offices that are on for this August. So that is why the Election Commission ruled the way it did and why the Department of Law opined the way it did. That's based on 20 years of precedent and interpreting that phrase to mean that. So now we have a ruling from the Supreme Court that definitively says the way the charter is written right now, that phrase as it relates to vacancies in the office of district council member and mayor, that means the every 4-year August election.
Thank you. Even though the one that talks about the judicial ones is under that heading of general metropolitan election. Okay. Thank you.
Thank you, Council Lady Allen. Seeing no further discussion. Yes, Mr. Chairman.
May I make just one further point with your indulgence? One additional factor that I failed to mention is that the state election coordinator and the state election commission who appoints us, we were appointed by the state, they agreed with Metro Legal's analysis of the law. So we had that in addition to what at least I felt was a common sense reading of the Metro Charter. So those were two additional reasons why we did what we did.
Thank you, Mr. Chairman. Mr. Holland, one last comment before we take our vote.
Sorry, the state coordinator of elections is not the authority on the charter in no way, shape, form, or fashion, and the Supreme Court said so.
Thank you so much, Mr. Holland. Thank you, Mr. Chairman. Thank you, commissioners, for coming and providing us with the information as to how we got to this juncture. It is unfortunate as it relates to, I don't know if it was a mistake or interpretation, not suggesting that. The point of having all parties involved is so that we can be accountable to the taxpayers. And this is an unfortunate, expensive circumstance. So thank you so much for coming. Seeing no further discussion, all in favor? Opposed? Resolution passes. RS 2018-1165, sponsor Scott Davis, appropriates $500,000 from the General Fund Reserve Fund for the purchase of equipment and building repairs for Metro Nashville General Hospital. Is there a motion? Councilman Davis.
Thank you, Madam President. I'd like to defer this for one meeting with a brief explanation, please.
I need a motion to defer. Second. Councilman Mendez, were you seeking recognition? All in favor? Opposed? Resolution is deferred. One meeting, correct?
Yes, ma'am.
Okay, the mic is yours.
Thank you. I am excited that, and I want to applaud the administration for including the beds for the hospital inside the budget. Now, there's going to be a conference call, I believe, tomorrow with the administration and the hospital. It is my intent, to then amend that 4% fund for the $500,000 to provide something else the hospital needs. And I want to applaud once again the administration for their commitment to helping the hospital. However, though, there's about $26 million or in other basic repairs that are needed. And I would like to make sure that that money that was so generously given back into the 4% fund, the money that we weren't expecting to come back, to be used to help stabilize the hospital. Now, what I want to applaud my colleagues is there, and the mayors and the administration for wanting to help the hospital, but we want to go far and beyond the call of duty. So once again, I applaud the administration for its efforts. I applaud everybody here that's worked hard, but I want to be clear that hospitals help everyone. And so by adding that $500,000 to another part of infrastructure that the hospital needs, that is my intent. And furthermore, I'm going to be expressing, may not be in legislative form, but the need of not appointing board members that may have a conflict of interest with other hospitals. And just like, if I'm on Google's board, they won't let someone from Facebook or Microsoft or, a competitor be appointed to their board. And so, that's a separate subject, but we have to do what we can to keep the hospital going. And I just want to thank everyone for their cooperation, and I will be amending that 4% request to provide other needs of the hospital. Thank you.
Thank you, Councilman Davis, for applauding everyone. Seeing no further discussion, there's a motion to defer. All in favor? Opposed? Resolution is deferred. RS 2018-1166, sponsors Virtue and Betnay, approves a grant from the Tennessee Administrative Office of the Courts to the Metro Juvenile Court for the interpreter translation services for individuals with limited English proficiency. Is there a motion? It's been moved and properly seconded. All in favor? Opposed? Resolution passes. We're almost there. RS 2018-1167, sponsors Virtue, authorizes the Metro Department of Law to compromise and settle the personal injury claims of Tank Maxwell Saunders, a minor by Shatika Good, his mother and next friend, and Shatika Good, individually against the Metro government in the amount of $150,000. Is there a motion? Come on, it's been moved and properly seconded. Council Lady Henderson, you're recognized.
Thank you, Chair Virtue. This was concerning to read. I do support the resolution, but it did raise a question for me when I read the analysis, and I wonder if Legal Director Cooper could speak to the employee that was found at fault, his subsequent plea to other things. I note here that he resigned rather than he was fired. Can you speak to when we have an employee who pleads guilty to the things that this person did, what that means from a benefits perspective?
Director Cooper.
There is a state law that talks about employees who are convicted as a result of actions taken while in office that are related to their job. And there is a provision for withholding or revoking pensions in that case. There's a provision in the Metro Code that allows pensions to be revoked for certain types of conduct. In this case, the illegal conduct was not directly, I mean, I don't know that it arose out of his employment, but I mean, I don't know if this individual was even vested in the system. I don't know how long he had been employed by Metro. Someone from Parks may know that. But there are mechanisms under both state and local law for addressing pensions for people who are convicted of things arising out of their employment.
So from Metro's perspective, if this person was convicted of this in the context, I mean, does that mean it has to have transpired on Metro property in the context of his job? Does that mean he came into contact with somebody?
I don't remember the specific language in the code. I think my recollection is that it references actions as a result of the employment or taken in actions that were done in furtherance of the employment. So, I mean, the benefit, I can email you that code section if
I appreciate the code section. I would like specifically to know as to this employee based on this, what that meant for him from a benefits perspective. I don't think somebody who commits these sort of actions should have.
I mean, he was not granted a pension because he was not eligible for one. So no pension has been granted.
I didn't understand that from your remarks. I thought you were speculating that was the case.
No, well, I mean, being vested in the pension does not mean you're eligible to receive it. So, I mean, based on his age and his years of service, he would not be eligible to receive a pension until some time in the distant future.
And health care benefits, nothing like that?
Same, right.
No benefits.
Correct.
Thank you.
Director Odom, that you want to?
I did. I just wanted to add a bit of clarity for this, the employee that you're speaking about. He was a part-time employee, and so he did not have any benefits.
Thank you so much, Director. Councilman Pulley.
Don't go anywhere. Thank you very much, Madam Chair. I just have a couple of questions and they could be for Parks or Attorney Cooper. It appears as though, to me, from the standpoint of liability and anything that we had from a policy perspective that deals with this, it's obviously a tragic circumstance and sad that it happened, but it looks like, based on my reading of the analysis, it's a he said, she said thing about who was told what regarding the child's circumstance for swimming. Is that correct?
Correct. I think a troubling fact is that the registration form did not include a question specific to this.
And that's
that has been rectified. The form now clearly asks that question. So yes, we have the mother saying, I told them that he was not allowed in the pool, and we had the person who was over the center not recalling that.
Okay. Is Mr. Williams the person he wasn't the person over the center, right?
Right. He was
part-time employee.
Yeah, over that, or had something to do with that program.
He was a part-time.
All right. And does the mother alleges she told Mr. Williams or the director of the center that he was not supposed to swim?
I think it was the director of the center, Andrew McClanahan's back there. He can confirm that.
She said she told the program director.
Good afternoon. The testimony in the case is that the mother told the center manager that her son was not allowed to swim. She acknowledged that conversation occurred, but thought that that was only relative to one occasion. And the other testimony is that she told the program supervisor, which was Dwayne Williams, and that is the person who has the criminal charges. So it would be a he said, she said between those two individuals.
All right, so and any reason why we didn't have this on the form originally?
I'll defer that to Parks.
I'm Sherry Hips, Superintendent of Community Programs, and for years we've had a form reviewed by Metro Legal, and until this case came up to our awareness, did we have direction to revise it. So we did immediately after the incident, so that the next summer we had that in the form. And we've continued to revise policy to gain safety of the children that swim in our programs in the summer as well as the rest of the year.
All right. You feel like that's compelling enough, Mr. Cooper, to where we should use that to settle this? The fact that there was no a place on the form for her to note her objection to swimming, or I'm assuming that your decision is based upon that and the lack of credibility to go along with the witness?
Absolutely. Yeah, I think
that put it over the top?
Yes, because in order for Metro to walk away without paying anything, the court would have to find that the mother was at least majority at fault, 51% at fault, and we felt like given the facts and the credibility of the former Parks employee, that was very unlikely. And so given the amount, I mean, I think the medical bills were pushing $130,000. So given the meds alone, we would be looking at a cap case of $300,000.
Okay. All right. Well, thanks very much. That satisfies my question.
How often are the forms reviewed by Metro Legal?
Annually, each summer, we review them before we use registration, which we just completed registration this past Saturday.
Thank you. Seeing no further discussion, all in favor? Opposed? Resolution passes. RS 2018-1168 sponsors Vircher, Bettany, and Roten, approves an option agreement between Metro government and Samuel and Marcia Morgan for the purchase of property owned by the Morgans. Is there a motion? It's been moved and properly seconded. Seeing no discussion, all in favor? Opposed? Resolution passes. RS 2018-1169 sponsors Vircher, Roten, and Allen, approves a grant from the Nashville Airport Authority to the Metro Parks and Recreation Department to assist in the planting of trees in Nashville. Is there a motion? It's been moved and properly seconded. Seeing no discussion, all in favor? Opposed? Resolution passes. RS 2018-1170 sponsors Vircher and Gilmore, approves Amendments 1 and 2 to a Tennessee Cooperative Agreement to Benefit Homeless Individuals Grant, which is jointly funded from the Tennessee Department of Mental Health and Substance Abuse Services to the Metro Social Services Commission to enhance and develop the infrastructure of Tennessee and the treatment service systems. There is a letter to approve. Is there a motion? It's been moved and properly seconded. Seeing no discussion, all in favor? Opposed? Resolution passes. RS 2018-1171 sponsors Gilmore and Allen, authorizes the continuation of the Vehicle Inspection and Maintenance Program for motor vehicles registered in Davidson County, originally implemented to attain and maintain compliance with national ambient air quality standards. There is a letter to approve. Is there a motion? It's been moved and properly seconded. Councilman Pulley, you recognize. You hit it.
I thought you said Polly.
Pulley.
I'd just like to ask Mr. Sharp a question or two. This is in response to the state legislation that was just passed in regards to this?
Yes, sir.
Okay. And obviously the state saw fit to abolish these things across the state. Can you tell me why we're doing this?
So I'm Tom Sharp from the Health Department. The state abolished it everywhere except for any place that ran its own program. That is, it abolished it everywhere except for here.
I'm specifically getting to our need to continue doing this.
Well, so here's what I would say to that. If this resolution does not pass, when the contracts that we have currently in place, which you approved last summer, expire in the summer of 2022, you will not have an option to continue the program whether you want to or not. This will allow you to take the time to see what the landscape looks like after Williamson, Wilson, Rutherford, and Sumner stop doing this. We will have a lot more data. We'll have a lot more information. We'll have a lot better view of what it might take, what we might have to make up if this goes away when that decision time rolls around, when the contracts expire in 2022. If this resolution does not pass, you will not have the discretion to make that call. It will go away.
All right, thank you.
Thank you, Councilman Pulley. Councilman Mendez.
I think I have a politically incorrect question, but I'm going to ask it. Do we have data about whether modern vehicles need the emissions test in order for us to know whether or not it actually matters to air pollution? I know there's some older cars on the road, but there's a lot of newer cars, and I'm curious at this crossroads whether we've got data on that.
Mr. Jameson.
My understanding, and I will look to Mr. Sharp to echo this, is that about roughly 10% of vehicles that enter our vehicle inspection program fail. Whether or not those tend to be more modern vehicles, I would guess not, but I will defer to Mr. Sharp.
Mr. Sharp?
The percentage decreases the closer you get to brand new. We've already tested, believe it or not, one 2019 model year car. How that happened, I have no idea. It passed. So far, they're perfect. But the older cars will fail at an 18, 19% rate, and it gets progressively better. But the new ones, brand new ones, will fail at roughly 2, 3, 4% a year.
And in total, it's 10% of the tested cars fail?
Yes, sir. On average, about 10% a year fail.
All right, thank you.
Thank you, Councilman Mendez. Council Lady Allen.
Thank you, Madam Chair. Mr. Sharp, can you just talk a little bit about what the standards, why the standards are there, and how automobiles figure into the pollutants that these standards regulate, and what effects those have on health?
So I've brought the technical experts with me, and I may get them to pitch in here, but by far our largest source of air pollutant is mobile sources, most of which is automobiles. By making sure that the automobiles are in proper working order, the models, the way they check these things, estimate that it keeps on the order of 400 tons of air pollutants a year out of the air. And so if that goes away, we would be faced with either making it up somewhere else possibly, or some other issues. And it's a health issue. That's why it's in the health department. We're particularly worried about ozone. We are close to the ozone standard, which was lowered a couple, 3 years ago. We bump right up against it, particularly on hot summers. It can be very difficult for us to maintain that compliance. And I would say that going out of attainment with the National Ambient Air Quality Standards is really not a position that the city would want to be in. It can be devastatingly expensive in terms of economic development, transportation funding, and some other things. It's not a place we want to go.
Thank you, Council Lady. Councilman O'Connell. Oh, Councilman Bettany.
I'm incognito. No, I like to sit here because I don't want to get in front of him and hide him. So I wanted to share, you guys, many of you, most of you supported us when we tried to pass the legislation. We succeeded in passing the legislation to limit gas compression stations in residential neighborhoods. One thing I learned during that process is that although a gas compression station produces the equivalent of 900 vehicles running 24/7, the biggest, by far, pollutant in Nashville is our vehicles, the cars that drive. We have like 30,000 cars driving on Owensville Road, 20,000 cars driving on Burkett, and I'm sure the same is true in all the other streets in the city. Now, we have this referendum happening tomorrow, which may or may not pass, which may or may not limit the amount of polluting vehicles on the road. So the issue here is, if we don't keep a lead on the amount of pollutants that we have in the city, our ability to allow some industrial uses in our community is going to be jeopardized, because there is a limit to how much pollution we can have in the city. And so I know some of the people listening in have an issue with us creating this hardship, but we are really not trying to create hardship. We're just trying to keep the city viable and healthy for most people. So I'm supporting keeping our ability to test these vehicles, to keep it under control as much as possible. And I hope that, by the way, thank you for letting me speak. I'm not on the committee, but I hope that you all will support it, because pollution is a big problem, mostly for people like me, that everybody in my family is allergic or has asthma and has breathing problems. Thank you.
Thank you, Councilman. Councilman Pridemore.
Thank you, Chair. Just approaching this from maybe a different angle, and also maybe at the sake of sounding greedy as representing Metro, are there any...
This is Budget and Finance.
We're right in line then. Are there any grants, federal grants, pass-through grants that the air quality of air standards are attached to, or the testing attached to any of the requirements of those grants? I know this is right out left field, may not have that answer, but I don't know if Mr. Sharp would.
So this is John Finke, who's our Air Pollution Control Director. It depends on whether you're in attainment or not. Is that correct, John? There are other grants attached to you having decent air quality. Is that the question? If you get out of decent air quality, if you go out of attainment, they can ratchet down on transportation funding and other things.
The two grants that the Metro Health Department have, we would have whether we were in attainment or not attainment. The risk that you run is that the surrounding counties have essentially abolished vehicle testing. It is no longer an option for them in the future. They do not know yet what EPA is going to decide as to where that burden shifts. TDEC is going to have to spend the next 6 to 12 months determining what happens from getting rid of their vehicle inspection programs. It's possible that EPA says you can absorb that change and you're good to go. It could be that they shift that burden to commercial, industrial, municipal sources. They don't know yet. And that's why this resolution gives us the opportunity to not make that decision today. By passing this resolution, it grants you time. Since we have a contract through 2022, we have time to go through this process with TDEC, with EPA, and see what the alternatives are. If the resolution does not pass, you remove one of those alternatives forever, and it's not an option for us in the future. So the resolution just keeps the door open. It's not a vote to keep vehicle inspection forever. It's just an opportunity to learn more before you make a decision.
Which creates the possibility of actually losing funds down the road. Thank you. That's all I have to say.
Thank you, Councilman. Councilman Roten.
Thank you, Madam Chair. Tom, thanks for being here. Hey, do we have, and I apologize if y'all said something, I was out in the hall talking with someone. Do we have the numbers on how many cars actually travel in? If you've already said it, I apologize. Travel in from out of county that will not be tested?
That's a good question. Do we know that, Louis? So it has been, do you know?
I believe we checked with the testing contractor. In 2016, we tested 570,000 cars, but only 525,000 were registered in Davidson County. So about 45,000 were from surrounding counties.
I don't know. I don't know if some of ours were tested in outside counties, but Davidson County in 2016 had approximately 525,000 registered vehicles.
Okay, in the surrounding counties, we don't know the numbers for those counties, is that correct?
It's ballpark, it's about, the surrounding counties add up to about the same as Davidson.
So about the same number of cars possibly traveling into the county that will not be tested now, correct? Is that correct?
Roughly the same number of vehicles are registered in those 4 counties as are registered in Davidson.
And the vehicles that do not pass, you said it was, what was it, 2 to 4 to 5%? Usually those are older cars, is that correct?
It averages about 10%. The older the cars get, the more likely they are to fail.
And the older the cars get, we'll call them much more affordable, is that correct?
Perhaps.
I think cars are more affordable. I'm talking about Councilman Pridemore's car, but the older the cars get, the more affordable they get, which usually means people with less money buy those vehicles. I've always thought of this, especially if we're going to get rid of, and I'm going to go back talking to the chair, if we're going to get rid of testing all in every county around us, and then the only cars that are being tested are those owned by the poorer citizens of Nashville, then all this is really now is a tax on the poor, a big tax on the poor, because if they can't get their car to pass, they have to go spend $500, $1,000, $2,000 to get their car to pass, when most of the cars on the roads now are not even going to be tested. It really bothers me that we're kind of short-sighted here on, we say we're wanting to protect the air. Every county around us is not going to have it. They're going to be driving into our county, and all of the cars will be polluting the air just as, I just don't understand why Davidson County wants to be the only one. It's my understanding from the legislation that passed that we have the ability to add a little bit on to our registration fees to make up for any funding that we might lose. And I think my opinion would be that that would be the better route to go than just to put the entire pollution system of Nashville and the surrounding counties on the poorest Nashvillians. And I'm just going to leave it with that. Thank you very much.
Thank you, Councilman. Mr. Sharp, do you have a...
Mr. Roten, we're aware that that can be an issue. There are a couple ways that we're trying to make it more user-friendly and recognize that it can be a burden on some folks. One is that in the contracts that y'all approved last summer, we're going to take up to 25% of the fleet out of the garage testing altogether when we get the regulations updated so they can go through the remote sensing. So it'll be less burdensome in terms of time. We're also looking at ways to incorporate a hardship waiver for people that just simply cannot afford to get their car fixed right now. They can get a waiver for a year so that they have a year to try to get it fixed. And again, I would note that you're not making the decision today about whether to continue this for the next 4 years. This is to give you the option, if we can get it in a condition that you find more acceptable by 2022, and we know what the implications of doing away with it are more clearly than we know now, we can make that decision then. You can make that decision then. This keeps this quiver in your arrow for when the time, in your arrow in the quiver for when the time comes.
Thank you, Mr. Sharp. Councilman Davis, do you have anything to add to the discussion that has not been articulated? I'm trying to move us along.
Well, 2 of my questions was answered. Thank you, Councilman Roten, for bringing that up. My next question is, the waiver that we're going to institute, will that allow the people to get their tags? Because most of the time, you know, when you don't pass MARTA, you can't get your tags renewed, and then you have a chance of getting pulled over by the police department. So by that waiver being issued, will that allow them to renew their tags for a year?
Yes.
Thank you, Councilman. Seeing no further discussion, all in favor? Opposed? Resolution passes. Thank you, Mr. Sharp. RS 2018-1172. I'm sorry? You want to be recorded as no? Thank you, Councilman Roten.
I got
RS 2018-1172, sponsors Roberts, Virtue, and others, approves an intergovernmental agreement between the Tennessee Department of Transportation and Metro Public Works for the reimbursement of railroad crossing safety improvements at Centennial Boulevard. Is there a motion? It's been moved and properly seconded. Seeing no discussion, all in favor? Opposed? Resolution passes. RS 2018-1173, sponsors Roberts, Virtue, and others, authorizes Metro Water Sewage Services to enter into a facility encroachment agreement with CSX Transportation to acquire or accept dedication of certain facilities to be built by a private party. Is there a motion? It's been moved and properly seconded. Seeing no discussion, all in favor? Opposed? Resolution passes. Now we're on to bills on second reading. BL 2018-1161, sponsors Syracuse, Virtue, and others, approves an agreement between Metro Government and Plaza 2750 LLC for the acquisition of property for use as the site for a new public library branch and acquisition and construction-related infrastructure improvements in Donaldson. Is there a motion? It's been moved and properly seconded. Seeing no discussion, all in favor? Opposed? Bill will be recommended. Now we're on to bills on third reading. BL 2018-1124, sponsor Hurt, amends the adopted building codes regarding public bathroom facilities. Do you have a letter? Don't have a letter. We don't have a letter from the sponsor. This will be deferred by rule. BL 2018-1143, sponsor Johnson, Mina Johnson, Murphy, and others, approves an agreement between the Tennessee Department of Transportation, City of Belmead, CSX Transportation, Department of Public Works for payment to CSXT for the costs incurred during the construction phase of the bridge rehabilitation project at the Hillwood Boulevard Bridge over CSX Transportation Railroad crossing at Richland Creek. There is a letter to approve. Is there a motion? It's been moved and properly seconded. Seeing no discussion, all in favor? Opposed? Bill is recommended. I want to take this opportunity to remind committee members that we will begin our budget hearings next week, and we are adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.